All I showed was proof that the truck was insured,
No, you,
registered.
all right, I'm not gonna deal with it. All right, let's set a trial
So
date. Set a trial date.
I'm trying to get this dismissed.
Well, it's
This is
not going to
literally
be
holding me
dismissed.
back right now.
You get it
Okay.
dismissed on the date of trial. Date of trial.
Well, nice. Thanks for not. Thanks for. No, I see clear as day why I'm not getting the same courtesy. Your name is Sean Perkins. Yeah. Okay.
That
I
is.
will.
That's the last time I checked.
Yeah. 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 Okay. I get it. It's all.
Mr. Gubin.
I don't need to hear it. I don't need to hear the blabby blabby blab. Just stop talking to me.
I was just gonna ask, did you want to go in a breakout room?
What is a breakout room? I showed all my proof. I showed all
Miss,
the
miss,
proof.
miss,
I showed the proof, Mr. Sean Perkins. What is it? Is it my what is it? My
have a good
complexion?
day, Mr. Have a good
It's my
day, Mr.
complexion, isn't it, buddy?
Have a good
Yeah.
day, Mr. Gubin.
Mr. Uneducated Judge.
Have a good day, Mr. Gubin. You keep on
How are
talking
you
out of
even a
turn.
judge, bro?
I'm gonna hold you in contempt, okay? And we're gonna give you some jail time, okay?
In seconds, the moment he threw out that complexion comment, you could feel the air leave the room. This isn't just a disagreement anymore. It's personal. And the judge, he's already shifting from patient to fed up.
So I understand that may be the court's position. I just got retained on this matter this morning. I was not present at the hearing where you apparently held him in contempt. He obviously has an opportunity to prepare and present a defense to the allegation. I'm not sure if the court made a finding as to whether or not this was civil or criminal contempt, and further, whether the court actually determined whether it was direct or indirect contempt. Obviously, the court's ability to sanction especially with a deferred sanction, may be limited under these circumstances. So what I'd be asking the court to consider doing is giving me a brief adjournment so that I may obtain a copy of the transcript of the last hearing. And I would just cite to case law, which indicates that my client does have the ability to obtain an accurate transcript of the hearing as a matter of due process. And when we come back, I will be prepared to effectively, properly address this matter.
Just like that. 30 days. No more talking. No more chances. Most people would freeze at that point, but Sean still thinks he can talk his way out. Spoiler, it's not working.
Was the contempt was right on the record on the record, and I do have you can get the record for that. It was I did hold him in criminal contempt. That's why I told him 30 days Wayne County Jail. And from my understanding of the court rules, he had his opportunity to contest that. That ship has long sailed, from my understanding of the court rules, because this was done over a year ago. And the only reason that Mr. Gubin has come back before me is because he got some other cases. He let the tickets go on the warrant status. He only is before me because he got the other cases. So I still need his presence here. I'm going to readjust his bond now.
Your
He
Honor.
hasn't. So he continued. I've let you speak, Counselor, and I'll let you do what you need to do as far as your job. But I'm going to do my job. And Mr. Gubin continues to defy the court's orders. And
This is a totally different approach. Quiet, methodical, all about the law. She's not matching the judge's energy. She's redirecting it. Due process, legal classifications, transcripts. She's trying to force the judge into a corner with the rules.
We'll talk about bond right now. City of Detroit versus Joshua Gubin. Case numbers SP 1411448. Count 1 and count 2. SP 1669671. Appearance for the record, please.
Yes, good morning, Camilla Barkovic, appearing on behalf of the defendant who is present.
Your Honor, Rami Hijazi, P82830 on behalf of defendant as well, Your Honor.
Okay, so you can make the record now as far as what you want to do, either counsels if you want to, as far as Mr. Gubin is concerned. Today, we'll call the date and time. There's 2 warrants out for Mr. Gubin's arrest. Let me see what the action was the last time. Mr. Hijazi was here last week when he appeared on Mr. Gubin's behalf after Mr. Gubin showed up, and I realized that he was the gentleman that was just very, very contemptuous on that day that he was here last year. The allegations were made on December the 7th, 2022. Mr. Gubin was arraigned on those matters February 29th, 2024. There was a show cause scheduled for August the 15th, 2023. And the register of action can reflect all the other necessary court dates that were had. But Mr. Gubin has shown that he does not comply with the court's orders as far as appearing before the court. Mr. Gubin has shown that he is very, very contemptuous. This is not something that I have done except for one other time. And Mr. Gubin, I gave him a week from last week to get his affairs in order to turn himself in, and he's still not here. Go ahead and make
that ship sailed a year ago. Translation: we're not reopening that box. You can see it. The judge isn't angry here. He's just completely closed off to the argument.
Speak to bond.
Thank you, Judge. I've already articulated some of this to the court off the record, but I was just retained to represent Mr. Gubin in this matter this morning. I am asking for an adjournment of today's hearing so that I may obtain a copy of the transcript of the hearing that was held where you apparently held Mr. Gubin in contempt. He does have a right to counsel in any contempt situation. In addition, he does have a due process right to obtain an accurate transcript of the hearing. I would like to obviously obtain all relevant information and then address this matter appropriately. I'm asking that you take no action today and give me the opportunity that I am requesting on behalf of my client. And if you'd like me to transition into the bond issue, I am happy to do. It is my understanding that mere traffic matters are pending before the court, at least one civil infraction, and I believe a no insurance misdemeanor. These incidents date back to 2022 based on my review of the Register of Actions. He has appeared in connection with this matter, which the court has noted. Apparently he was here last week, and you may have recognized him. But the point of the matter is, I've known Mr. Gubin for a while. He always appears as required and as instructed. I understand that the court may have a difference of opinion as it relates to that, but I would attest to that. He is a lifelong Michigan resident. He has extremely strong family support. He is a father. He has minor children, actually, one of which is visible on the Zoom as we currently sit here. He owns his own business.
Now we get the human side. A dad, a business owner, a community man, the kid visible on Zoom. That's not random. That's a deliberate way to soften the judge's view. The problem is, this judge has a long memory.
All right. Very well. Bond is going to be set at $2,500 cash. I still, the order of Mr. Gubin still showing up because despite what you've articulated on the record, Ms. Bachowicz, I we put the warrant out for Mr. Gubin's arrest a long time ago. He was supposed to be in person here today. He's not. He also has an assault and battery case that he has a warrant out for his arrest for as well. So he showed the court and demonstrated to the court that he has not only with this court, but with the other court courts and other judges in this courthouse that he has a failure to appear or something. So bond is $500 cash, and it's still ordered that Mr. Rubin show up in person to the court for the conviction hearing, and we will address, and you can appeal the matter to a higher authority if that's.
So, Your Honor, I have a comment as it relates to a cash bond. I'm asking that the court impose a cash or surety bond. My interpretation of the court rules as it relates to bond and statutory authority allow the defendant to elect whether he posts a surety or posts a cash bond. And my position is the court cannot outright prohibit a surety. So I'd ask for the addition of a surety provision.
The court has made its ruling, Counselor. You can take it to a higher authority.
Thanks.
500 cash, no bondsman option. The defense makes one last push, but it's a hard no. That's the end of the road. And for the second time today, we see the same lesson. Once you lose a judge's patience, you lose control of your